Okay, we are here now in the matter of Fogle versus Clay Elementary Schools and others. Mr. McMichael, you may begin.
Good morning. May it please the court, opposing counsel. The question presented on this appeal is one of statutory interpretation. It's whether the Iowa Municipal Tort Claims Act and its recently enacted qualified immunity standard applies to claims brought under the Iowa Civil Rights Act. The district courts have been dealing with this issue at a high rate since the enactment of that qualified immunity provision. And in this case in particular, the district court held the IMTCA did not apply to those ICRA claims, holding that the definition of tort underneath the IMTCA was not broad enough to encompass ICRA claims. Defendants argue that that decision was an error and should be reversed. The court should focus on the plain language of the statute in this case, which is the IMTCA. And under that definition of tort, it's clearly broad enough and does encompass ICRA claims. The IMTCA lays out to what extent municipalities and its employees and officers can be held liable for civil action. And it provides that they can be held liable for torts. But the legislature didn't leave that term undefined. It specifically went out of its way to define what tort meant underneath the statute. And in doing so, it defined it very, very broadly to include every civil wrong, including but not limited to a breach of a duty that includes a denial or impairment of any right under any statute. Where it's clear under that definition, Iowa Civil Rights Act claims fall beneath that.
I agree. If all we had was that definition of tort, you'd have, you have a reasonable argument either way, but I think your position would be stronger. But then we also have in the qualified immunity provision itself, it says, it refers to a claim brought under this chapter. And then we go to 216.16, which is the Iowa Civil Rights Act, and that has its own exclusivity provision that basically says civil rights claims are brought here. And so when we combine 216.16 and 670.4a, why aren't we at a situation where 670.4a doesn't apply?
Well, I think looking at 216.16, it is true that that's where Iowa Civil Rights Acts are brought. But I don't think that means that the IMTCA does not also encompass those claims to provide additional protections to municipalities and its employees and officers in which those claims are brought. Plaintiffs point out their kind of preemption argument that the Iowa Civil Rights Act preempts other common law claims based on that same conduct. But I think it's important to point out that that's not the situation we have here. The Iowa Municipal Tort Claims Act does not create a new cause of action. What it's doing is determining under what umbrella civil rights action or under what umbrella causes of actions can be brought against municipalities and its employees and officers.
Specific claim that was brought in this case. It was under 216.9, which makes it a discriminatory act specifically for an educational institution to do something. But qualified immunity applies to employees and individuals, not to institutions. So why does qualified immunity even apply to the specific claims under ICRA in this case?
I think the qualified immunity provision within Chapter 670 provides that if qualified immunity is held to exist as to employees and individuals, then it also exists as to the municipality.
Specifically says an employee or officer subject to a claim shall not be liable. But under 216.9, an employee doesn't owe a duty under 216.9. Only the school district does. And so if 670.4a is directed only at employees and officers, And in this case, I believe that the plaintiffs only brought their ICRA claims against the school district, not against the individuals, setting aside aiding and abetting. But the two main ICRA claims are only against the school district. Is that correct?
Yes, Your Honor, but they are trying to pull in individual liability under that aiding and abetting claim as well. And
I just want to look at the two specific ICRA claims that are brought against the school district. Does qualified immunity under 670.4A even apply to that claim?
I would say underneath the language, if individuals aren't determined to be protected by the qualified immunity statute, then it does not apply to the municipality. That being said, 670.4A is different than like federal law, where qualified immunity isn't even applicable to municipalities like it is here. Qualified immunity is applicable under 670.4A to municipalities where there's individuals held protected by that standard.
With our recent decision in Doe, because I think in Doe we said actually that 670.4A really did adopt the federal standard.
I think, while that might have been some of the intention of the legislature, I also think that ignores the differences between 670.4A and federal qualified immunity. And one of those things is federal qualified immunity does not apply to municipalities like it does here under 670.4A under certain circumstances.
For what circumstances would 670.4A apply to the municipality and not to the individual?
Where the employer officer was determined to be protected by the qualified immunity under this section. So, where a Civil Rights Act, like in this case, was brought against individuals, then the qualified immunity standard would apply. The other difference between federal law and state law that I think is important to note here is that individuals cannot be held liable under Federal Civil Rights Act like the ADA or Title VII like they can under the Iowa Civil Rights Act. And so I think just to solely base our analysis off federal law and ignore the differences between the two would be contrary to the statute and improper. I do want to address Doe because Doe pointed out that common law claims were not included under that qualified immunity standard, but it specifically set forth that constitutional claims as well as statutory claims were. Well, here that's exactly what we have is a statutory claim. And what Doe pointed out was we're looking at what is the right, privilege, or immunity secured by the statute. Well, clearly here the Iowa Civil Rights Act secures protection from discrimination within employment and education law. And again, it provides potential liability for individuals that the qualified immunity applies to and then applies to municipalities as well based on that application. I think one thing I want to point out is what the consequences could be of not applying the IMTCA just in general to Iowa Civil Rights Act claims. 670.8 provides that municipalities are to protect its officers and employees when they're sued underneath the statute. And so I think since individual liability was allowed under the Civil Rights Act in 1999, we've seen an uptick of claims against individuals that really don't have a good basis, and that individuals are simply being brought in because of their position within the municipality or public entity. And I think respectfully, that's one of the issues in this case as well. Plaintiffs have brought in the superintendent really simply based on his position within the school district and not based on his involvement in underlying action. So I think qualified immunity here is important to protect those type of instances.
Is the common law claims against the superintendent?
Say that again.
Recent Doe case affect the common law claims against the superintendent?
And we would concede that Doe means that the qualified immunity standard does not apply to those common law claims, which were included in this in this lawsuit. So that obviously between the time we appealed and provided our briefing, Doe came out and kind of changed the landscape a bit, and so we're aware of that. I do want to address the Southern District's decision in Dickey v. Mahaska Health Partnership, which the district court relied on and plaintiffs have relied on to some extent. And while we respect that decision, it's non-binding, number one, and we think it was improperly decided. And one of the main points to be made is that court relied very, very heavily on the traditional understanding of what a tort is, to then simply imply or speculate that that's what the legislature meant when it enacted the IMTCA and utilized tort within the statute. But
Wrong. I mean, we generally say that, a word kind of means what it means until defined differently.
defined differently here. I mean, the legislature chose to define it differently within the statute. In fact, in 1974, expanded the definition from what it was originally to include what it is now, which is any...
The definition includes statutory violations, but there are things that are statutory violations that would also be, we would also consider to be analogous to traditional torts. Things like, for example, a violation of a statute that provides a standard of care, a negligence per se type situation could be a statutory violation, and we would also regard it as a tort. But as Judge Locher points out, we don't think of civil rights discrimination claims as torts.
I think number one, the statute doesn't, set out only, tortious statute. It provides any right under any statute. And so I think under the language, that's all encompassing. Number two, I would argue against the claim that, ICRA claims or civil rights claims are not tortious in their nature. They set forth a restriction on actions, a duty not to act in a certain manner, and provide a remedy for that action. And federal courts have looked at those type of claims and synonymized them and analogized them to tortious actions.
Right. Would the same analysis apply to civil rights claims against the state and the state qualified immunity provisions?
I believe it would, because
Who, as a plaintiff, for example, or defendant, navigate those two competing regimes of the Iowa Tort Claims Act processing piece and then the Iowa Civil Rights Act and the Civil Rights Commission processing? How do you reconcile that?
I don't think underneath the statute, and specifically, when we're talking about Chapter 670, that those two statutes compete, but can be worked together, and that claims can be brought through the Iowa Civil Rights Commission under its procedures and administrative avenues, while also still meeting the requirements of the Iowa Municipal Tort Claims Act.
And the Civil Rights Commission sort of at the same time? Is that what you're thinking?
I think when looking at the state appeals process, I think it would need to be looked at on how those two statutes would intertwine and be worked through. But
Limitations would you be bound by? The one in the ICRA or the one in, or it really applies, this is a question for both statutes, or the one in the Tort Claims Act?
So that the ICRA would be the statute of limitations to bring that administrative action, which is the 300 days. And
The, whatever it is, not, 90 days.
and so I think the Iowa Municipal Tort Claims Act statute of limitations of 2 years would still apply, but that statute of limitations applies to actions for monetary damages underneath the statute. And so obviously the ICRA also encompasses injunctive and remedial relief.
So here the plaintiffs have asked for injunctive relief. You agree that's clearly not covered by the Tort Claims Act?
Well, yes, in terms of...
that part doesn't have to be pled with particularity.
But they've also claimed monetary damages as well, and so that's encompassed still in the same claim, and so it's still the same claim, just asking with multiple damages.
Miss the whole case if the particularity only applies to part of it. I mean, maybe they haven't made this argument, but to me it shows, kind of this whole line of questioning we've been going on kind of tends to show what Judge Locher was saying, which is it's two separate paths, not one path.
I think, and I want to wrap up, if that's okay, is that the emphasis should be put on what the legislature provided within the statute and the plain language of that statute. The legislature has had the opportunity to exempt ICRA claims under 670, but has not done so despite that ability. And so I think looking at the clear, plain language of the statute, what it provides, the torts that are encompassed under it, and under the decision of Doe, that this is a statutory claim that the IMTCA should apply to ICRA claims. Thank you.
Good morning, and may it please the court, counsel. My name is Marrissa Pasker, and I represent the plaintiffs in this case. There are three main issues here. First, whether or not defendants had the right to appeal the district court's denial of the motion to dismiss. Second, whether or not the qualified immunity and heightened pleading standards of 670.4a apply to Iowa Civil Rights Act claims. And third, whether or not plaintiffs sufficiently pled their common law claims. It's clear when looking at our precedent and the applications of our laws that the district court correctly ruled on the defendant's motion to dismiss. I first want to state our position on whether or not this case is procedurally proper. It's our position that qualified immunity does not apply here. And if qualified immunity doesn't apply, the heightened pleading standard doesn't apply. And if neither of those apply, then this case is procedurally improper.
Should be dismissed.
Yes, so the
Interlocutory, you don't have a right to an interlocutory appeal unless you're under 670. Is that what you're saying?
they could have applied for an interlocutory appeal, but there was no immediate right to appeal, which is what is granted under 670.4a. Yes, yeah,
Right. Did we address that issue in Doe? I mean, in Doe, I think we said we said it didn't apply, the qualified immunity didn't apply, but we said the pleading standard and qualified immunity went hand in hand. And so in that case where, and that was a grant, but where if you're denied a motion to your motion to dismiss on the basis of 670.4a generally, then that's still, those all go together. And so then sub 4 that allows for the appeal would also apply.
the district court's holding, it wasn't a denial of qualified immunity or the heightened pleading standard. It found that it's inapplicable based on our long history of case law and how the IMTCA has never applied to ICRA claims. And this court has never directly ruled on that specifically, but in the future, when a claim under that has never historically been applied under IMTCA is brought up, will that be considered a denial of qualified immunity? So that's why we are claiming that it is procedurally improper. And turning now to specifically 670.4a in the ICRA, the holdings in Dickey versus Mahaska Health and Doe versus Western Dubuque are instructive on this issue. And in following the analysis from both of those courts, this court should not stray from our precedent now and apply the IMTCA where it has never applied before.
Counsel, about the argument of your opponent that if the legislature had wanted to exclude ITCA claims, that it could have done so expressly.
Although they could have done so explicitly, they didn't need to because the definition of tort doesn't include an ICRA claim. And our courts have never found it to include an ICRA claim, even though civil rights claims are not specifically excluded. It has, the IMTCA in Chapter 670 has never been applied to ICRA claims. So there was no need to explicitly exclude it because the intention of the legislature was not to include it.
Problems would result if we were to try to harmonize these statutes and say that qualified immunity and pleadings do apply to an ICRA case.
Plethora of potential issues that would arise. First of all, the ICRA requires that a plaintiff go through the administrative exhaustion requirement. That includes filing a complaint in the Iowa Civil Rights Commission. Well, if 670 applies, then would it also apply to that complaint within the commission? And a plaintiff can also choose to continue their claim for damages against a municipality or the state through the commission and never bring it to district court. So would 670 then also apply to those claims that are maintained within the Iowa Civil Rights Commission? And as it was brought up earlier, the statute of limitations issue. Iowa Civil Rights Act claims have to be brought within 300 days of the last discriminatory act, while claims brought under 670 and that are covered by 670 have a 2-year statute of limitations. So that's also in direct conflict. There would be a plethora of issues that would arise, along with the fact that the discretionary function exception within Chapter 670 would then apply to Iowa Civil Rights Act claims, which has never been applied before. And this would make individuals immune from liability if they were exercising their discretion. But that wouldn't serve the purpose of Chapter 216, which is to correct broad patterns of discrimination. And it needs to be read broadly to effectuate that purpose. And so that would go against Chapter 216. And in addition to that, another problem would be that we would have different standards for claims against private actors and municipal or public actors, which nowhere in Chapter 216 or in our application of 216 is it implied that there should be different standards for municipal or state actors and private actors. It says all educational institutions, which has included private and public institutions, are held liable for their discrimination. All employers, which has included the state or a municipality, along with a private employer, should be liable for their discriminatory actions. So then we would have two different standards, which in our over 50 years of precedent has never been there before.
All those problems if we just hold that the ICRA exclusivity requirement in the statute means what it says.
The plain language of that, if we want to go with a plain language argument, 216 is the exclusive means to bring a discrimination claim. And the legislature granted plaintiffs the ability to bring claims against municipalities for their discriminatory acts when they enacted 216. And then Chapter 670 specifically says for claims brought under this chapter, which 216 claims are not brought under that chapter.
Argument that 670.8 that indemnifies employees and officers under ICRA under IMTCA should apply to an ICRA claim?
Could you repeat the question, please?
And Counsel was talking about the things in IMTCA that should be applied to an ICRA claim to help protect. And so one of them is 670.8, which indemnifies, which requires the municipality to indemnify the officer. Can you address his argument with respect to that?
Yeah, I mean, 670 in its entirety doesn't apply to ICRA claims because under the definition of tort, it doesn't include in Iowa Civil Rights Act claims.
Called that. And that under ICRA, does ICRA have its own indemnity provision? And so does it address that itself?
Underneath the Iowa Civil Rights Act, both employers and the individuals can be liable. And our case law has shown that employers are held liable for the actions of supervisors or those who have the ability to effectuate the discrimination is what the case law says.
Case where an employee sued under an ICRA claim claims that they need to be indemnified without going through those separate standards, right?
No. I also want to address the holding in Doe versus Western Dubuque. I think that that is very important here. The court decided that common law claims are not covered under 670.4a, but they are covered under Chapter 670 broadly. Common law claims are negligence, breach of fiduciary duty, nuisance, and those are explicitly listed in the definition of torts, and they have historically been considered claims under Chapter 670. So the plain language argument by opposing counsel doesn't follow here because of the Doe holding. The plain language of, even if an ICRA claim is a tort under Chapter 670, the plain language doesn't affect the application of 670.4a, because we have to look at the intention, the timing of the enactment. 670.4a is based off of federal law, and it was enacted to respond to Godfrey and the cases that followed. And in looking at federal law, this court looked to Dickey and looked at an example of when Chapter 670 does not apply, which is to Iowa Civil Rights Act claims. So this court relied on Dickey as an example of when we should not apply Chapter 670, which is exactly the issue before the court today. I want to address briefly the issue of individual liability under 216.9 that was brought up earlier. It's our position that 216.9 does permit individuals to be sued for their discriminatory actions, again, because of the purpose of Chapter 216, and that it's supposed to be read broadly to effectuate that purpose. And in addition, everywhere else, individuals are liable within 216. And in 216.11, it makes individuals liable for aiding and abetting in a discriminatory act. And so it would be illogical to think that the legislature intended educational institutions to be liable, but not the individual actors who were carrying out the discrimination.
Not illogical.
If we look everywhere else within Chapter 216, it has an entity liable and also the individual actors liable, and that's what we have here, especially considering, again, the purpose of Chapter 216.
So if they've done it everywhere else and the legislature specifically didn't here, maybe the inference is they wanted to protect teachers and people who are employed by school districts in a way that they didn't want to in other capacities.
That's a narrow reading of Chapter 216 because the purpose of 216 is to correct broad patterns of discrimination. And to
We wouldn't have to address that argument if we agreed with your other argument that it's a separate path. Sorry. Problems with the buttons this morning. We wouldn't have to address that argument if we agreed with your argument that that it's the Civil Rights Act is that 670.4a doesn't apply to Civil Rights Act claims at all anyway.
I think that it still is an issue for the court to consider. It wasn't raised directly in our appellate brief, so it was raised by opposing counsel on their motion to dismiss below that individuals aren't liable, period, under 216.9. And even if the court did find that to be true, 216.11 does create individual liabilities. It states that every, quote, person, which includes individual human beings, is liable for aiding or abetting another, quote, person, which includes an entity like a school, for discriminating.
Did that ever before? I'm surprised. That issue before, whether there's individual liability for educational institutions, civil rights claims like this.
The court has looked, I don't think that that issue has been brought directly to the court's attention. It's usually more on like a breach of fiduciary duty claim that the court has addressed the issue of individual liability.
What additional relief would the plaintiff get if the entity can be held liable for the acts of its employees anyway?
Well, because we're at the early stages in this, we don't know who the most bad actor is. We don't have discovery yet to see everyone's specific actions. That'll be an issue to raise on motion for summary judgment.
Odd formulation to say that an employee can aid and abet the corporate entity that employs him. when the basis for liability is the employee's own conduct. That seems a very odd workaround to the statute, to me.
This court has held that 216 does create a separate liability and a separate cause of action from other discrimination claims. Granted, that was in reference to an employment discrimination claim, but 216.11, if it meant to exclude educational institutions, it could have included that in there, and it didn't. It says any person aiding in any discrimination. It doesn't say discrimination against employers and homeowners and housing. It says any discrimination.
That makes it discriminatory is the 216, is it 9? Yeah. I mean, otherwise there wouldn't be any unlawful discrimination other than 216.9, which says who should be liable.
Holds the institution specifically liable, and we argue also the individual, but even if it's just the institution liable, a person can still aid that institution in discriminating. So that's why the individual defendants here are liable. And I just want to briefly conclude here and say that the district court correctly found that the IMTCA does not apply to Iowa Civil Rights Act claims. And the district court even found that plaintiffs' common law claims meet the heightened pleading standard, which isn't the standard we need to meet. This court should not stray from our precedent and potentially lead us down a confusing path of IMTCA application where it has never done so before. We ask this court to uphold the district court's holding, clarify the inapplicability of the IMTCA to Iowa Civil Rights Act claims, find plaintiffs' common law claims were sufficiently pled, and remand this case to the district court for further proceedings. Thank you.
While the issue wasn't on appeal, I do want to just quickly address the 216.9 individual liability issue that was brought up at the district court level. And I apologize, I don't have the specific case references at hand, but the federal courts have already decided this issue. The Iowa courts have not, but there's two separate cases that have determined that under 216.9, there is no individual liability, and you cannot circumvent that by bringing a separate aiding and abetting claim. So that, we believe that issue's been determined already, even outside of the language.
Cases.
Does that have? They are, yes. So outside of that, I want to address some of the things that plaintiffs' counsel said. I want to go to how the Iowa Municipal Tort Claims Act and its heightened pleading standard was applied in NAHAS. And now we understand that, at least as to how the qualified immunity standard was looked at in terms of being separate versus as a whole, has been overruled in NAHAS, but it doesn't appear that the application of the heightened pleading standard was overruled. And in that case, it was applied to Chapter 21 and 22, and I think it's important to note that, you know, claims under closed session and confidential record provisions in 21 and 22 are not tortious in the traditional sense, and so I think that really undermines Locher's decision in Dickey. I also think it's important to note that Chapter 21 has its own statute of limitations as well, and yet the court still decided that the qualified immunity standard, the heightened pleading standard under that provision, applied. The other aspect of the application of the heightened pleading standard to the closed session, to Chapter 21 and 22, again, is that there was no finding that this was not applicable because it was not a tortious claim. Instead, it was simply, we looked at the language of the statute, which is this was any right under any statute, and so it was applied. I do want to touch on 670.8 as well. Specifically, that provision provides the governing body shall defend its officers and employees, whether elected or appointed. And so the outcome of not applying the IMTCA to ICRA claims is now that provision no longer is in effect, and there is no.
By that statute in an ICRA case?
I've not found any case law with which it was applied, but in practice, we have looked at that in our practice to determine whether the municipality, the entity, needed to defend individuals. And again, I think it's important, given that there's been an uptick in cases where we're asserting ICRA claims against individuals simply on their basis of a position and not on their actual involvement in the alleged underlying discriminatory action. And so, to me, not applying the IMTCA really opens up the door to further baseless ICRA claims against individuals not really involved in the discriminatory conduct.
That NAHAS issue. And the qualified immunity provisions are fairly new, and parties are raising different arguments. And it seems like the difficulty created by the provision is it's trying to solve two problems: constitutional tort claims in Godfrey, and really implied causes of action where somebody just points to a statute or a regulation and says, the officer technically violated that and I'm suing. And it seems like it's wholly inapplicable to me when you have entirely a statutory regime that's comprehensive, like open records or ICRA. I'm sure there are others that you could think of. And maybe our early cases didn't deal with that distinction. What would be your response to that if really we're talking about kind of unexpected liability for officers for statutes that just come out of nowhere, whereas like ICRA, for example, I did HR law, you do it. Everybody's trained all the time on civil rights acts. It's not like this is a surprise to an officer who works for a school district or a municipality. So it seems like those are very different to me.
I think, again, it's important to go back. I think the court in doing that is trying to speculate on the scope of the qualified immunity provision based on, when it was enacted after Godfrey. And certainly we understand that it was enacted in response to Godfrey, in response to those constitutional tort claims that were permitted. However, the legislature, that case has now been overruled, and the legislature has kept in effect this qualified immunity statute. And again, it did not provide within that provision that it was only qualified immunity for constitutional tort claims. It said claims brought underneath this chapter. And again, the IMTCA's definition of tort, by its plain language, encompasses the ICRA claims we're discussing today. So for those reasons, we think the district court got it wrong and should be reversed, that the IMTCA applies to ICRA claims. Thank you.
Fogle versus Clay Elementary School and others is hereby submitted. Court is adjourned until this afternoon.